Hi everyone and welcome to Legal Aid Queensland's webinar on consumer leases. My name is Catherine Bowden and I'm the Community Legal Education Officer here at Legal Aid, and sitting next to me today is Loretta Creek. Loretta is the Senior Lawyer in our Consumer Protection Unit. So I'll be the facilitator today and Loretta will be going over the presentation, but before we begin I just want to go over a few housekeeping slides. So just so you know, this video is for community legal education purposes only. It is being recorded today as well. Okay, and once we've recorded it and captioned it, we'll be publishing it on our Information for Community Workers and Carers page on our website. So make sure you take a look there. Okay, I'd just like to test that you can all hear us and see us and the software's working. Could you just raise your hand in the right-hand side toolbar if everything's okay? Great. I can see some hands raised there. All right, you can go ahead and pop those down for me. So most of you should be joining in by mic and speakers so you can hear and see us. And if you'd like to go ahead and download the handout, in the right-hand side toolbar, you'll see one handout which is the PowerPoint slides today. So I'll just give you a minute to download that PDF. All right, now normally we do a 40-minute presentation with 20 minutes for questions at the end, but Loretta's welcoming questions throughout the presentation today. If she gets a chance to get to them during the presentation, she will. If not, we'll still keep those for the end. And we'll let you know once the presentation's ended and we're calling for additional questions then too. All right, we just want to run a quick poll with you all, so if you could please answer the following question for us: where is your work or office located? So we're looking to see if you're in Southeast Queensland, rural, regional, remote Queensland, or outside of Queensland. I know it doesn't match up to the PowerPoint slide. Apologies for that. Please just answer as the poll. So we've actually got a large percentage of you from outside of Queensland today. The majority are from outside of Queensland. And we've got a lot of you from Southeast Queensland and quite a few from regional as well. So just close that poll off now and share the results with you all. So you can see we had 40% outside of Queensland, 36% in Southeast Queensland, and 24% in rural, regional and remote Queensland. Okay, we're going to run a second poll. So if you could please let us know how much knowledge you think you have of Legal Aid Queensland at the moment. And hopefully we'll be able to build on that today as well. It's looking like most of you have a really good knowledge of legal aid, so that's great to hear. And I can see that there's still quite a few of you not in Queensland, so hopefully you know of your own legal aid within your own state. Just give it a few more seconds there to get all of you voting. Okay, and we'll share those results with you now. So again, most of you have a good knowledge, which is great to hear. Some with a limited knowledge, and I'm sure you'll learn a lot more today about legal aid. And as I said, I'm the Communication and Community Legal Education Officer here, and I'd just like to again introduce Loretta, our Senior Lawyer in the Consumer Protection Unit. I'll hand over to Loretta and she'll begin her presentation. And before I do so, I'm just going to move myself out of the screen so Loretta can take full view there.
Hello everybody. This is actually my first webinar that I've ever done, so it's a bit of a learning experience for me. And I'll see how I go, especially with questions, because I do usually like to take questions throughout the presentation, because I think that's how everybody else learns, because somebody's always prepared to ask the question that everybody else wants answered, but everybody's a bit scared to ask. I did get 2 questions before the presentation as to what people wanted answered, and it actually came from a creditor's perspective, and the 2 questions were really about, you know, how just as a creditor do we know whether the person has the capacity to understand the contract, and the second question is, how do we identify affordability? Now, when you're working from the other side, of course, we're looking to see, well, did the person actually understand the contract that they entered into, and was it affordable? So I thought I might just answer it quickly and then give some more detail as we go along throughout the presentation. So about understanding the contract, I want to just say this is a question that's been asked of me over many years by creditors, and I want to make this caveat. One of the things that I think is really important is that we don't exclude people from getting credit on the basis of any intellectual disability, because it's not about excluding people, but it's about ensuring that the contracts that people enter into who have limited capacity actually understand what that they're receiving and that they can afford it. So I always say to people, there really isn't a single solution to that question about understanding, and you really need to tailor it to the individual. I've got a case study within my presentation, as you'll see in the handouts, and I'll explore that a little bit more, and that sometimes it's quite easy to pick up whether a person has issues around understanding and that you might have to do a little bit more, and also that, you know, and affordability. But can I just say, one of the first triggers for me asking more questions about whether a person understood what they were entering into is the source of their income. So if it comes from a disability support pension, it's really, you sort of know already that you should be asking more questions as to their understanding. But then there's the other side, and I think we really tend to forget that as creditors or people working in the industry, it depends on the honesty and integrity of that person who's asking the questions, and whether they're really interested in finding out whether that person understands what they're entering into, or they just want to sell the product. Similar, I think it's, and going on from that, it's really about the organisation's remuneration structures and the culture of the organisation. And there's been a lot of that in the media, that where the culture of the organisations in some of the banks has not been good, then the products that they've sold to people have not been appropriate. And then the other question about affordability, again, it really is, I mean, the regulatory statements put out by ASIC, by the Australian Securities and Investment Commission, about affordability are a really good place to go, both from a creditor's perspective and when you're trying to work out whether this person should have got the loan, what the creditor should have taken into account. But I think, you know, from many years of looking at people's contracts, I can work out pretty quickly if they could afford this or not. And income sources, again, a very good indication of whether they may or may not have problems being able to afford the contract. So anyway, that's what I'm hoping to get through in my outline, but as you can see, I like to talk, so it may actually take me a bit longer than I expected. But anyway, let's get into the main part of the presentation. So what sort of consumer leases are we talking about? We're talking about leases that are actually regulated by one piece of legislation, really, the National Consumer Credit Protection Act, and that is in itself, and the National Credit Code. And the National Credit Code is actually a schedule to the National Consumer Credit Protection Act, and was, for some of the community workers that have been around for a lot longer, was based on legislation itself that was state-based legislation. It was, and was really uplifted into national legislation about 6 years ago. So the consumer leases that are regulated are only those that are predominantly for household or domestic purposes. So the goods are hired predominantly, wholly or predominantly for household or domestic purposes. What that means is if the purpose is for more than one purpose that the goods are used for, if more than half of the use of the goods is for domestic purpose, it will be covered. So in a number of matters that I've seen or we've seen at Legal Aid, is one of the examples was where a mother was running a daycare centre at home, so needed a car to transport her 5 children, but also needed it for transporting any children in her care. She had to go and pick them up or drop them off. Now, that was a mix of business and domestic purposes, but presumably in that case we would have used the car more for domestic purposes than business purposes, and therefore would be one that was regulated. There's a charge for the leasing. What we mean by that is that, of course, everybody charges for leasing goods. You'd expect that. But the charge is made for the hiring of goods that, together with any other amount payable under the contract, exceeds the cash price of the goods. So, for example, where the cash price of the goods, say, for example, a car is $10,000, and the repayments under the lease are only $8,000, you'd say, oh, well, maybe that's not regulated. But it also includes any other amounts that are payable. So if they say, well, at the end of the lease, we think this car's still worth $5,000, then that, together with the $8,000, would exceed the $10,000. It means it's covered. And the last thing is, just like normal contracts to be regulated by the National Credit Code, the lessor has to be in the business of lending. Now, well, in business, if the lessor must hire the goods in the course of the business of hiring goods, or as part of or incidental to any other business of the lessor. So, for example, if somebody sells furniture and on one occasion, but they don't generally lease furniture out of that business, but on one occasion they decide to lease the goods to your client, then that contract would still be covered because the person was in the business of in a business, and it was incidental to their business of selling furniture. So, which goods are not regulated as a consumer lease? Well, where there's a right to buy the goods at the end of the term. So if the consumer has the right to buy the goods, the contract will be regulated as a hire purchase. So it'll be still regulated, but it'll be regulated as a credit contract rather than as a consumer lease. And this was often the case with car contracts, where ownership of the vehicle was retained by the lender until the last payment, and then the contract provided that the ownership would be transferred on that last payment. So that's why where there's and we'll talk about where there's a right to buy at the end, it would be regulated under the general provisions. Now, novated leases, they're really employer leases. So consumer leases under which goods are hired by an employer in connection with the employer's remuneration or other employment benefits are not regulated at all by the National Credit Code. And this is even though the employee has ultimate responsibility for ensuring repayments should their employment be terminated. So in one case where I gave advice in previously, they'd only been employed for a couple of months, got this lease, and then was terminated. It was not a contract to which the National Credit Code applied. Now, there might be other things that you can do, and we'll talk about that later, but generally they're not. Short-term leases or indefinite leases, what we mean by short-term leases is leases under 4 months would not be covered. So your typical car hire for the weekend when travelling interstate would not be regulated. And with indefinite leases, this was one area where some companies were using to try and avoid regulation. They just said that the lease would go on forever. But the Australian Securities and Investment Commission has really cracked down on that, and a lot less companies are using that as an avoidance strategy. And of course, where payments do not exceed the cost of the goods, which I've just spoken about previously. Please, though, remember, if you see somebody come in with a lease that appears not to be regulated, so you don't have the box which says, you know, is a warning statement and all those sorts of things that generally make you think, oh, I don't know if these people are saying this is a regulated lease. What you always do is go back to the lessor and say, we think this is regulated, and that do you belong, what's your license number, and do you belong to an external dispute resolution scheme? Because the presumption is that the legislation applies, and it's up to the lessor then to come back and say to you, well, we don't think the legislation applies because of these factors. And where you do still think it applies, that's where you really want to make a complaint to the regulator. Now, because I'm a lawyer and we all like disclaimers, oh wait, I need to go back. So this is my disclaimer. I've noticed that 40% of you are not in Queensland. The most significant thing that would be different, that would apply differently in the different states, is about enforcement. So yes, when you're going into the contract, a lot is the same. It's national legislation, except that there are some differences in Western Australia, but generally speaking, when you're going into the obligations on creditors are the same, regardless of which state that you come from. But when it comes to enforcement, enforcement generally takes place in state courts, and there are differences between how that enforcement happens in those different states. So if in Queensland, if a consumer fails to pay, the lessor will usually seek to recover possession of the goods and then issue a claim and statement of claim. And if the consumer doesn't respond, then they can obtain judgment after a period of time has passed. If you're located in another state, you would need to check what the requirements are in that state. Please, though, again, this is something that's very important, that under the National Credit Code, the lessee or consumer has to be sued in the state that they reside in, even if the contract was taken out in a different state. So now we get on to, well, what are the obligations on lessors, lenders, when giving leases to our consumers. Now, there's two separate sections in a way, is that there's responsible lending requirements, which I'll talk to you about, and fairness requirements under the National Credit Code. So responsible lending requirements are actually contained in the National Consumer Credit Protection Act, and they're really about they really place obligations on lessors, on credit providers, that allows them to be licensed. So all lessors are required to be licensed if they wish to provide consumer leases. And the National Consumer Credit Protection Act actually requires as a license condition that the lender comply with the responsible lending requirements. What that basically means is the responsible lending requirements is the contract suitable for the client? So there's lots of fancy words that go around that, but that's basically it. Lessors can meet that obligation as to being responsible when the consumer can pay without substantial hardship, and when the credit meets the consumer's needs and objectives. So this is where I spoke to you about the Australian Securities and Investment Commission at the start of the presentation, when I talked to you about a document that you can look at to see whether the person understood or whether the contract was affordable. It's Regulatory Guide 209, and it's really good both from a creditor's point of view, but also as a consumer worker, trying to work out whether the credit provider did the right thing. So what should the lender take into account in assessing a consumer's capacity to meet their repayment obligations? So that regulatory guide says they should base the assessment of a consumer's capacity to meet their payment obligations on the reasonable inquiries that have been made about the consumer's financial situation and the reasonable steps that they've taken to verify that financial situation. So they not only have to make the inquiries, but they do have to take reasonable steps. And it depends on how big the contract is as to what would be reasonable in those circumstances. So a payday loan for $100 will have a lot less, possibly a lot less steps than something where you're, borrowing $500,000 to buy a house. With those reasonable inquiries about a person's financial situation, you can, though, look at the combined incomes of a couple rather than assessing each person's capacity separately. But also, that's usually what we as community workers always focus on. Well, what was the financial situation and could they afford it? But we often forget about the requirement to assess a consumer's needs and objectives. And that, again, is really covered off in that regulatory guide. So when you're making an assessment that a credit contract or consumer lease meets a consumer's requirements and objectives, you have to match what the consumer has said with a credit contract or consumer lease that meets those needs in essence. That will depend on the circumstances, and some of the things that they can take into account is the nature of the credit requested by the consumer and the consumer's stated objectives in obtaining that credit. Now that just is a little bit convoluted, but what that really means is that if you go in and say you want to buy a car and you want to own a car, and instead they give you a lease, then we say that that's not meeting your stated or the consumer's stated objectives. It also, one of the other things that they've really talked about, and there's a whole other list that not only applies to consumer leases, but this is one of the things that I thought was really important, is the consumer's understanding of the proposed contract, and for consumer lease, whether the consumer is aware that they will not own the goods at the end of the contract. Thank you for that about the spelling. So I've had a question. Judgment or judgment, need to get the spelling right, folks. So yes, I'll take that on board. I've had a problem with that all my life. So thank you. Then the other area is that not only can you look at the requirements under the National Consumer Credit Protection Act, but you can also look at whether the contract itself was unfair, and that's contained in the National Credit Code. And the other question, can people see, I'm just going to ask Catherine a question because I've had another question asked of me, and I'm just going to ask Catherine if everybody can see the questions. Can everybody see the questions?
No, Loretta, so only we can see the questions. So if you do want to respond to the question on the screen, just read it back to the audience first.
So the other question that's just come in for me is, so how does assessing both people's income accord with whether a contract has been entered into under duress, whether one party derives no benefit but is liable for the debt jointly and severably? I think that's separated, because when I spoke about assessing people's income, I was talking about whether it meets the objective of affordability. It's not about whether it meets the consumer's needs or objectives, or whether the contract was unjust, because whether the contract is unjust does take into account those sorts of factors about whether the person entered the contract under duress, or whether they understood their liability for the debt jointly and severally. I hope that answers it, but if you want a follow-up question, please let me know. So was the contract, so the other thing that you can look at is, was the contract unfair? And those sorts of things, again, you can have a look at the legislation itself. It's section 177F, which mirrors in essence the unjust contracts provisions, which mirrors in fact the unjust contracts provisions that are contained in section 76 of the credit code. And they look at things like whether the debtor could protect their own interests, age, disability or influence. Again, it talks about capacity to pay and the relative bargaining powers of the parties. Now, those lists, yes, it's put in a list in a sense, but in a sense it's about the whole circumstances. And again, this is why a case study is so good, because you can really see about the unfairness of the whole situation, not just about picking out things from a list and saying, yes, well, obviously in most cases when we're dealing with the bank, we're going to be in a relatively weaker bargaining position than the bank. But it's about the whole circumstances, not just meeting all of those tests. I'm going to talk to you a little bit about special rules that apply to consumer leases, but also I'm going to add a few more that I don't have on the slides that I thought about after I finalised this. So the first thing is that with consumer leases, interest rate cap, there's an interest rate cap, general interest rate cap of 48% on credit contracts, except if they're small amount credit contracts or medium amount credit contracts, which have some different rules, and caps on the fees and charges that you can charge on general credit contracts. There's none of those on consumer leases, so they can charge whatever they like at the moment. The other thing under a general credit contract is you can't take security over household goods. So some of you that will have been working in the area for quite a long time will remember, you know, people having security taken over their doona covers and doona covers or a cutlery, or in one case the cat, as my colleague Paul always likes to point out. That obviously that was taken, that's no longer possible under general contracts, but in leases, of course, that's the whole basis of the contract, is you're only leasing the goods. So in fact, the ownership is always retained by the lessor. The written requirements that are required for consumer leases are less onerous than those for consumer credit contracts. But the good news is that again, lessors can't just enter into residential property to go and pick up goods. They have to, again, so this is the next special rule that applies to consumer leases. They, in fact, even though they own the goods, need a court order to enter residential property to take possession of goods, or they need the person to have consented in writing to the entry after being told in writing of their rights. And it's taken very seriously if they don't comply with that. So if you have those cases where, you know, a person is saying, well, they're threatening to come and take the goods, you can, you know, I mean, we suggest that they get legal advice about that, but, you know, rest assured that there are very strong provisions in the legislation which say what a lessor must do before they can come onto residential property. The other thing is, though, that if you return the goods early, there's a huge termination fee, and often it is in effect like you might as well have kept the goods for the whole period of time, because there's simply not any discount or very minimal discount for returning the goods early and wanting to pay out the lease early. So now we're on to the case study. So this also will draw out some of the issues. If this doesn't have all of my so Jill, well, obviously it's not a real name. She approached Legal Aid after she unsuccessfully attempted to resolve her issue with the lender, despite having assistance from her parents. So that, again, I just wanted to point that out because, you know, it sometimes reflects just the difficulties people have with the internal dispute resolution process or an external dispute resolution process. That even though that there's been so much stuff done to try and make it easier for people to complain, it's often just so difficult, and for ordinary people, let alone people who may have capacity issues. So in this, well, you can read it yourself. I hope that that's given you enough time to read it, because I'll just keep going on with the case study. Now, as you may have guessed, well, from that she does have some level of intellectual disability, but obviously she has the capacity to drive a car, so she's, you know, a lot further ahead than some, you know, that just because somebody drives a car doesn't mean that they may not have difficulties with understanding a contract. Stay with me. All right. So I'm hoping that will be similar to what you've experienced in some of the contracts that might come to you with a car lease, goods lease, or even with just a general contract. They're very individual, but if you get the facts behind the story, you already get the feeling, come on, this just doesn't seem fair. And often with these sorts of things is when you feel that something's unfair, there may be something in it. So how would you resolve that dispute? The first thing that you'd look at is, was the contract regulated? And in this, well, yes, the goods seem to be predominantly hired for personal, household or domestic purposes. The charge exceeded what the goods were worth, and the lessor was in the business of hiring goods. So yes, it looks like that contract was regulated. Was the lending responsible? Did it meet Jill's objectives and requirements? Well, arguably no, because she didn't want a car. And she certainly didn't want a lease because she didn't even know that she'd entered into it. And could she pay without significant hardship? I mean, that didn't come out in the case study, but you know, but she was on a disability support pension, and with an interrogation of her income, it would have been very difficult for her to make payments. Now, I always look at something like the Henderson Poverty Index to see whether the person could meet the repayments, but I also interrogate a person's bank account. And if you interrogate somebody's bank account, you can usually pick up all the things that they're paying that you may not be aware of. Like some things that I've picked up, like people paying pet insurance, or you know, things that they may not necessarily be able to remember that they're paying for, but they are actually paying. Or just recently, I had someone who made a commitment to pay a charitable organisation $20 a month or a similar thing. So I think that you could easily see from that example that contract was not responsible. But I also think it wasn't fair and it was unjust because, amongst other things, it was quite clear she didn't understand her obligations due to her intellectual disability and literacy levels, and they were not explained to her. And they should have known about that. I mean, she was a woman in her 20s, and she was she really made the point of saying, I need to take this home to my parents. I don't go and do anything without them. They're the sort of warning signs that, you know, that something may not be right. Jill didn't have the capacity to make the payments. She was pressured in, and that's the whole thing, she was pressured into signing the contract. The nature of the agreement was misrepresented as a loan rather than a lease. And what didn't come out in the case study, but was a feature of this, was that the car was itself not fit for the purpose of which it was purchased, given its poor mechanical condition. And that's actually the reason why she came to see us, because not only was she struggling to make payments, but the car was just unroadworthy. And the vehicle's cost was inflated to disguise the true cost of the lease. Now, in this particular case, she not only she tried to navigate that internal dispute resolution process that the lender is required to have as part of their licensing condition, couldn't do it. Her parents couldn't do it, but worse still, she wasn't really told about the fact that if she was unhappy with the resolution, she could make a complaint to an external dispute resolution body like the Credit and Investment Ombudsman or the Financial Ombudsman Service. And this is one of the things that is most disappointing, because we shouldn't have to help in all the cases and people should be able to do it themselves. But really that's the process that they needed to go through. And with our assistance, she did make a complaint to the Ombudsman Service and she was released from the contract. But not everybody has that opportunity and that assistance. So I just wanted to, some of the things that were brought out in that case study, well, I hope were brought out into that case study, was the consumer lease issues that we see at Legal Aid Queensland, and some of the, hopefully some of the changes that will be made as a result of the review of the legislation. And I just again wanted to separate out car leases from goods leases, but also car leases from novated leases. With novated leases, and that's why that's the employer leases, where the employer is paying for the lease payments whilst you're employed at that place of employment. There is an argument, and I said to you it wasn't regulated by the National Credit Code, but there is an argument that some of the other contracts that are provided as part of that lease, so usually when you have one of these novated leases, there's also a servicing contract that goes with it. There has been some authority to say that those servicing contracts may themselves be regulated by the Consumer Credit Code, and that's why you should just go ahead and, at least if they're part of an external dispute resolution scheme, you should at least be making the complaint. The problem is when the lease provider is not a member of the Credit and Investment Ombudsman Service or the Financial Ombudsman Service, your only option for those people will be to take the matter to court. And given that they don't have the resources to go and do that, you know, they can't make the payments on the car, they're unlikely to have the resources to go to court. And it's something that's, you know, an area, and they may not have any rights because they may in fact not be covered by the code. And the other vehicle leases that we see is, unfortunately, most of the time I'd have to say that they've been characterised as shams, because the cars are often, there's no contracts of sales, the cars are often roadworthy, and that's generally the reason why consumers come to us, and I'm sure that they come to you as well, because that's the pressure. They've got this car that they're making huge payments on, they can't actually use it. The worst example that I saw was somebody was paying $41,000 for a 7-year-old Barina, but typically we see borrowers pay 6 to 7 times more than the value of the vehicle. And in most cases, all my consumers thought that they were buying these cars. So with goods leases, To quote a solicitor from Legal Aid New South Wales, consumer leases are the new payday loans, in that consumer leases seem to be the more area of enterprise where traders seek to maximise regulatory gaps. It's mostly in relation to there not being any restrictions or prohibitions on the cost of the credit. So no cap on the cost of credit. So an analysis that I did of 20 contracts from the same provider, and the provider had actually given the retail value of the goods, so we were using their own valuation as to what the goods were worth new, showed an effective interest rate of between 100 and 300%. And I'd expect those to be fairly typical across the industry. Consumers are either told that they can keep the goods at the end of the term, or told that they can buy the products for $1, or not told that to purchase the products at the end of the term they need to pay an amount that is clearly much more than the second-hand value of the goods, and for which they've paid many times the retail value. They're also not told that if they choose to return the goods, even at the end of the term, there may be substantial costs payable for them. Goods not suitable for leasing. See, the argument is made that the reason why you need consumer leases is that there's, technological advances, and why would you want to buy like a phone or a tablet or a computer outright when you just want to keep upgrading? And that's a good argument for business, but is it a really good argument for consumer goods, especially because the sort of things that we've seen leased, and you may have seen leased yourself, is that one of our consumers was leasing a toaster and an iron, and I don't think they've advanced much in the last few years. In another example, they were leasing an air conditioner that had to be fitted to a wall, which then became a fixture of the property that they were renting, so they could never have given that air conditioner back. Avoidance of the National Credit Code. I've spoken to you a little bit about this, but it's also one where we still see business purposes declarations being misused. And I think it's important, if you think that this should have been regulated and the person said, oh no, I'm using it for business purposes, then I think you should make a complaint to the Australian Securities and Investment Commission, and even if they won't investigate it, at least it'll be on their books, and once they get a number of complaints, then they're more likely to take it on. Again, misrepresentation as to ownership, that's clear. The quality of the goods leased, vehicles leased, is another example. But the use of CentrePay to secure repayments has always been one of the reasons why I think these lease companies have used this system, because CentrePay Centrelink allows access to CentrePay when you're leasing household goods. Yes, they can cancel those CentrePay direct debits, but often consumers don't know that, and sometimes rental companies have come back and said to get them to re-sign. The other thing that we've seen in Queensland, and this may not be a feature in our other state, is rental companies complaining to goods if the goods are not returned or payments are not made. As goods are leased, ownership is not transferred to the consumer. A lessor could complain to the police that the goods were stolen if the consumer breaches the contract, does not make a payment. We've seen that sometimes in the past with leased vehicles, which is fine because, well, if you've leased something for 4 days and you don't return it, and it's 7 days later, you may very well have taken the goods. But in this area, we think that that's a real danger for consumers that consumers don't know about. So consumers no longer have the goods, even if it's in a domestic violence situation or in a homeless situation. It's good for the consumers to get some advice about what the problems might be. There's a few more questions, but I might try and answer them at the end because I'm just a little bit running out of time. And I just wanted to talk briefly about hardship. You probably get a lot about this. So, and most of you will know that a consumer can obtain variations on grounds of hardship if they meet 2 tests. are they in hardship? And this is the one where when consumers come and see me, they go to great lengths to tell me what their hardship is. And I go, I accept that you're in hardship, but that's only one of the limbs that you have to meet to be able to get a variation on the grounds of hardship. You have to be able to show, demonstrate that if the variation is given, you can meet all the terms of the contract. So if the person's in long-term hardship, like they're now on a disability support pension, and it's unlikely that they'll work again, and therefore they can't afford the lease in any event, that's not a hardship situation that the legislation provides for. That might be a reason to ask for debt waiver on the grounds of long-term hardship, but there's no legal right to ask for that, and there's no legal requirement for lenders to give a debt waiver on the grounds of long-term hardship. Should you stop asking for it? Of course not, because some creditors do have policies in place that and have made a commitment to considering those debt waivers on those grounds. I'm just going to tell you a little bit about where to get legal help. Like I always say, if I'm giving either advice generally or speaking to the community generally, I can't stress enough the importance of, even when you're helping someone, of that person getting legal advice early. And that's the most critical thing that I can tell you in relation to these sorts of contracts, is get the clients to not only get your assistance but also to get advice. We have a lot of offices in Queensland where people can come in for face-to-face advice across the state. That might be very helpful to people outside of the state, but that's for Queensland residents, because I sometimes think, particularly when our client group is very vulnerable, that they can benefit both from, might be able to benefit from phone or face-to-face, but that's why community workers are so important, because you might be the face-to-face contact with them and that you can assist them to get their legal advice. And our website, and that's the number that you need to call. And if your clients need help, if they're in Queensland, if you're in the other states, you really do need to contact your own legal aid commissions in that state, or the community legal centres in those states that might be able to assist you, because we won't be able to give advice to people about their rights interstate. Now, there are some questions. I'll see if Catherine can read them out, because my voice is nearly gone.
Thanks, Loretta, for that great presentation, and thank you to our audience as well for asking such great questions along the way. I'll just bring up the questions that we've got so far. So one person would like to know, Loretta, have you seen any consumer leases where the contract is finished and the consumer can donate them to another person? They read a case about this, about where a lady donated an item to her 2-year-old son.
I haven't seen those, but I'm assuming that's the sort of thing where they're trying to make sure that it can be regulated as a consumer lease, but in essence saying to the person, you've entered into a consumer lease, they can take advantage of those lesser requirements under consumer leases, but the client then knows that they in fact can donate it to somebody else, and to try and avoid regulation by the general sections of the code. But that's a novel one.
Thanks, Loretta. Another question we have here is that some community workers have come across with their clients consumer leases for goods that are listed as new goods, but they don't actually believe them to be new goods. So what happens then with the warranty?
Oh, that's very interesting. So that's so the warranties would not be under the National Credit Code. They'd be the warranties under the Australian Consumer Law, is as to whether they have warranties in relation to those goods. The problem would be under the Australian Consumer Law that there would be misrepresentations as to the goods. So warranties may very well, maybe not warranties might apply, but they might be in breach of their obligations as to representations made in relation to the goods, saying that they were new when they were not new. I hope that answers it, but that's a difficult one.
Thanks, Loretta. And we've got one more question. So if anyone else has other questions, please submit them now, because we've got about 5-10 minutes left to go through them. So,
oh, Anna, what about this one? Consumers look, there is a general question. I might just pull it out without naming the company, because we can't do that. But there is a consumer lease company that also are payday lenders, which enables them to access Centrepay for their repayment of payday loans. I think, can I say to you, I think Centrelink would be quite interested in that and might very well, look, in that particular case, I'd be complaining to Centrelink, because they would then have some ability to restrict that company from accessing Centrepay if they're not complying with their obligations with the contract between it and Centrepay to give them access to Centrepay. I'd also suggest that would be a case that I'd really be making a complaint to the Ombudsman scheme to which that lender belongs to, and really seeing if that's really something that would be a systemic issue and that they should be investigating. All right. Next question, Catherine.
Okay, so someone's experienced a consumer furniture lease, which was taking 22% of her gross income, which is the same amount as the rent. This contract was putting the client in a financial hardship, and it was being taken out of her family payments through Centrepay.
So, yeah, can I just say to you that that's one of the, well, it's clearly not responsible. I mean, you look at that, you don't even need more really in terms of saying, is that a responsible loan? And in that particular case, I mean, really we should be taking it to the internal dispute resolution and then going straight on to external dispute resolution if they won't come to the party as to whatever the resolution that your client is looking for. And this is something where, can I just make this point, that often, well, it just depends what the client's looking for. If they've paid, for the last 5 years, you really want to be asking for some of the money back. If they've just entered the contract, you might just be wanting to return the goods. That would really depend on how long that person has had that contract as to what you'd be asking for in the resolution. Now, Saskia's asked a very difficult question. So who holds the warranty on leased goods, the lessor or the lessee? Well, that's interesting. I think, well, in that particular case, I think it would be the lessor that's holding the warranty, because they're the owners of the goods. But you but of course, you have your rights under the National Consumer Credit Code, that your goods ought to be, in working order, or, you would have rights under the National Credit Code.
So we've got a question about strategies for women who have left because of domestic violence. Often a number of leases that become unaffordable for the single woman. So what would happen if someone was in a domestic violence situation and they wanted to leave? How would they then afford their lease?
Practically speaking, one of the things that you would get the client to do, but often we don't see these clients, is you would get the client to say, in a perfect world, you get the client to say, before they left, or just as they're leaving, I've left this premises, the goods are there, you can go and collect them, okay? What often, and this has been one of the issues that, and that's where they really need legal advice, particularly if the company is saying we're wanting to make a complaint about you to the police, because you no longer have the goods in your possession. You'd really want to get in very quickly with a complaint to the external dispute resolution scheme to say this is, this is very early on in the piece, to say, we've given the information that the goods are here, and for whatever reason, we don't think that we should be liable for the goods. But it also might be a way of getting, the lender might be able to get in there and get the goods back.
Thanks, Loretta. We've got time for just one or two last questions. Are you able to explain to us who are external dispute providers?
I'm very sorry. That just shows me that there's the level of knowledge within the room is, there's some people in the room that would have a very sophisticated knowledge, and some people in the room that don't have a knowledge. So with these consumer leases, it's a requirement under the legislation that you have a complaint mechanism to go to that's free for the consumer. And so it's free for the consumer. So in this particular case, the consumer lease providers are either a member of the Credit and Investment Ombudsman Scheme or the Financial Ombudsman Scheme. And so if the complaint's not resolved with the provider, you can go to these places and it's free for the consumer. And if there's a decision made in the consumer's favour, the lender has to pay. And if there's a decision not made in the consumer's favour, the consumer still has the option of going to court. So they're really good. Now, the Financial Ombudsman Service, and all you do is you go to their website, you search in the member to see which is the right external dispute resolution scheme. So, for example, one of the ones is the Financial Ombudsman Service. It's www.fos.org.au, and for the Credit and Investment Ombudsman Service is www.cio.org.au.
Thanks, Loretta. We'll just go for one final question. Are there age limits for leases?
No, there's not. But this is, again, where there's an intersection between the state and federal legislation. So, so for under 18-year-olds in Queensland, a contract isn't enforceable against them if it's not a contract for necessities. Now, that law is a state law. So it's not that it says you can't give a consumer lease, but in Queensland it might not be enforceable. In the other states there are different requirements. So again, for that, you would need to look at the state that you're in to get an answer for that.
Thanks, Loretta, and thanks to our audience. It's probably all we have time for today, but if you do have any extra questions, please do email us. The email address to use is webinars, WEBINARS, at legalaid.qld.gov.au, and I can pass those on to Loretta, and she'll do her best to get back to any of those follow-up questions. So I'd just like to thank Loretta again for a great presentation today, and our audience for such great, valuable questions. I'm sure those questions not only help you, but everyone else watching today as well. And we have created a survey. This is going to help us plan our program for next year. So if you could please take the time to fill that in, let us know what works and doesn't work for you and what topics you'd like to hear more of in the future. And we'll start that planning and let you know when the schedule is out. So thank you, everyone. Have a good day.